AABA, thank you so much for joining us, and APILO, our volunteers. This is our COVID-19 lease negotiations training. We are going to have this. We'll have questions at the end. So if you have any questions, please type them into the live chat box, and we will keep them for the end. We're very, very lucky to have two speakers today. Our first, ladies first always, is Ann Lee. Ann Lee is an associate in the real estate practice group at Perkins Coie. She focuses on real estate transactions, including leasing, purchase, and sales and financings. Alan Lowe is a real estate partner with the firm Perkins Coie, specializing in real estate financing, capital market transactions, and leasing. He also has an active pro bono practice, mostly representing nonprofit developers on affordable housing transactions, and he is the chair of AABA's Public Affairs Committee. Again, if you have any questions, please put them in the live chat. And Alan, take it away.
Thanks, Ezra, and welcome everybody. Good afternoon. I'm talking from my kids' study, so pardon the background with the books on SAT prep. Also want to point out that I finally put on a collar shirt after 30 days of being usually in t-shirts. Ezra, the next slide. Ezra, next slide. Slide after that. Okay, quick overview of our discussion. This webinar is focused on advising tenants on their commercial leases. It's intended for small businesses and nonprofit organizations. What you're going to hear today are what I really call levers. Nothing is a answer to the questions that you might confront when you're negotiating a lease. Certainly, in our experience in representing small businesses and nonprofits and lease negotiations, there's no formula to follow in order to get the rent relief that the tenant needs. But these are really some levers on which you can pull on to try to negotiate with the landlord. I also want to say that this is a constantly changing landscape. Just in San Francisco, there are maybe 4 mayoral orders all addressing commercial leases and commercial evictions. Ezra, next point. So the scope of this is really to talk about premises that are located in San Francisco. We can also expand the discussion to other cities and help you out if you're dealing with a lease issue in Oakland or in San Mateo. But for purposes of this webinar, we're really focused on San Francisco businesses and organizations. The qualifications to fall within these protections are that they're registered to do business in San Francisco and that their gross receipts worldwide is $25 million or less. So those are the 2 qualifications to fall within the protections that we're about to talk about. But this, we're assuming that everyone's going to qualify because this is really designed to help small businesses and nonprofit organizations. So I'm going to turn to Ann to kind of talk to you about a lease, what to do on a lease checkup. Ann?
Thanks, Alan. And hey, everyone, apologies. There's a bit of stuttering or just some video quality issues here. I know I'm working with a not so high quality webcam. I'm kind of looking off screen as well as my notes on this. So yeah, as Alan said, there's no real formula to these lease negotiations, particularly when it comes to kind of a smaller tenant versus maybe a larger landlord, or maybe even not so large of a landlord who is not so well versed or as sophisticated as other real estate investors. So I'm just going to go through kind of what we're calling a lease checkup, going through the lease terms and just kind of figuring out where you are with your particular lease. And a lot of this is going to be pointed at folks who may not really have real estate experience. So, first and foremost, rent. What kind of rent are we talking about when it comes to maybe an office lease or an industrial lease versus a retail lease? Rent can be paid in a couple different ways. You have base rent or fixed rent. The terms can vary with each one, which is just a fixed amount that folks pay monthly. You might also see percentage rent, which is much more prevalent in retail leases. And that's really rent that's paid based on a percentage of sales, maybe past a certain threshold. So you might see that with a restaurant or really any shop that depends on a lot of customer revenue. When you're looking at the rent provisions, particularly for folks who, are not able to pay rent these days, it's kind of important to know when is rent due. More often than not, it's a monthly rent, but maybe you have a couple of days of grace period, 3 to 5 days before interest or any sort of late charge is assessed. It's also important to know what kind of time frames there are for late charges, what kind of notice requirements that are required from a landlord before they're able to assess those charges as well. Operating expenses and taxes, kind of similar to rent, you'll also see this being referenced as additional rent, operating expenses, common area charges, common area assessments, common area maintenance, a variety of those terms. This really refers to a lot of the shared expenses in a certain property. So let's say you have a tenant that's part of a larger shopping center complex. The landlord might be taking care of a lot of the maintenance, and along with that, a lot of the insurance and the property taxes that are paid, and a lot of that gets kind of flows through to the tenant. So when you're checking for or you're negotiating some sort of abatement of rent, it's important to know, what is it exactly that you're asking for? Are you asking for a deferral of just the fixed cost? Or are you asking for some sort of abatement of utilities and all that as well? What we're seeing oftentimes is a lot of folks agreeing to give some sort of abatement on variable costs. So that could be maintenance charges, security guards, particularly if the area isn't being secured during, COVID, as opposed to like insurance and taxes. Those are fixed costs that the landlord is not really able to get rid of, so they're going to get billed anyway. The security deposit, important to take a look at what the notice provisions are there and how much is being held by the landlord. Some people are negotiating, letting the landlord take a chunk of the security deposit and having it applied to rent. But Alan will talk a bit about that a bit later as well when it comes to the eviction moratorium that's in place for San Francisco. Lease covenants, this can oftentimes refer to continuous operations clauses, going dark clauses. That's really sort of an opening and closing kind of covenant. So let's say you have a retail tenant in a shopping center, their lease might say that they have to stay open 7 days a week from 9 a.m. to 4 p.m. or some variation of that. Obviously during the shelter-in-place order, a lot of landlords are not enforcing these covenants, and we would say a lot of tenants have very reasonable arguments to say that they can't really comply with them. But it's important to know what they are in the event that once the order is lifted, is it really possible for your client to go back to work and keep their store open? Because on top of non-payment of rents and other breaches that they may have, this is one of those leasing covenants that the landlord can get you for on sort of a daily basis and assess damages for if you're not staying open. Improvement obligations. This oftentimes refers to both on the landlord and tenant side of improvements that they have to make to the premises. And it's usually on a certain timeline, with XYZ dollars going out the door for certain improvements. With COVID, obviously, a lot of folks are not able to get that done in a timely fashion. So you might have a force majeure argument there. And we'll get to that in a bit as well. The lease guarantee. So, with smaller tenants, you might see the lease signed by an individual as opposed to an LLC. But if there is an LLC, a lot of landlords will ask for a guarantee from the individuals, of the business backing up that lease itself. So, if it comes to for damages, oftentimes the landlord can come after the tenant, which is the entity, and then obviously the folks behind that if they sign the guarantee. Ezra, can you hit enter? Thank you. Events of default and default damages. So oftentimes in leases, you'll see an entire default section and remedies. And this obviously works in favor of the landlord. So an event of default can be defined as, like I mentioned earlier, some leasing covenants if you're not operating in your space. But obviously non-payment of rents is a big one. The damages that come with it, a lot of flavors, but generally, savvy landlords will say, if you're not paying rent, we can accelerate your rent almost immediately, and you have to pay us for what's currently due. Damages on top of that, so sort of administrative fees, but also the possibility of accelerating all rent that is due in the future. So let's say you're, 1 year in of a 10-year term. So all of your rent for the next 9 years could be due under the terms of the lease, or if they exercise some variation of remedies of terminating the lease, or whatever it is that they're working out. It's really just kind of damages on top of damages at that point. And in that regard, you should also take a look at the notice provisions. There's a lot of, I would say, just complying with those provisions is really important. First, just under the lease, and then secondly, under California law, to make sure that they're issuing their notices properly. Answer next. Force majeure, I'm sure that provision that most attorneys are familiar with these days with COVID. It also refers to frustration of purpose, impossibility, unforeseeability, impracticability, a number of terms these days. But really, it's something that we're looking at to excuse either payments or your obligations under the lease itself. Have we seen kind of folks bringing up this point successfully? Not so much when it comes to payment of rent, but when it comes to certain obligations, like obviously staying open, going dark closets, continuous operations. Yes, because we are obviously in a shelter in place, we can't have businesses running. Improvement obligations, sometimes you might have supplier issues that you can't finish your improvements in a timely manner. So we've seen people bring up the force majeure argument there. But when it comes to non-payment of rents, we've seen people raise it, but like I said, pretty much unsuccessfully. A lot of landlords are saying, just because you're not opening doesn't mean that you don't have to pay us. Nothing's preventing you from doing that. Obviously still recognizing that a lot of the revenue is coming from customers, but they're kind of seen as two separate things. Ezra, next. Ezra, thank you. Service interruptions. This refers to a clause in the lease that it kind of two flavors. Oftentimes, utilities and things that are required to keep a business running, but also access. So if you're not able to get to your premises, that might be a covenant under the lease that the landlord is supposed to do that, and that's a reason to, I don't want to say not pay rent, but it's another reason that, it's a lever, essentially. Same thing goes for utilities. Ezra? CC 1511, this is California Civil Code 1511. It refers to sort of a statutory right for force majeure. So like I was saying earlier, some leases might have a force majeure provision. In smaller commercial leases, we don't always see that just because folks have not negotiated for that. 1511 is sort of a statutory backdrop that gives a force majeure right without having, explicitly set that in a contract. But do keep in mind that the California Civil Code says that you can contract around that. So we've seen that in a lot of leases as well, where the concept itself comes up without reference to CC 1511, but they've essentially said force majeure is not a reason to get out of the lease or to not perform under the lease. We've also seen it as an argument, in other cases, not in the leasing context. So the doctrine itself is pretty untested, and even in those situations, we've seen courts kind of disfavor it. So just wanted to let you guys know that it's there, but again, not something that we're invoking successfully. Next.
Thanks, Ann. Now let me explain the regulatory framework of the commercial eviction moratoriums here in San Francisco. Ezra, next bullet point. First, the governor had issued an order that permits each county and each city to enact commercial eviction moratoriums. The governor's order doesn't really spell out how the moratoriums are supposed to work, and he leaves that to each county, each city to establish their own rules. So if you compare San Francisco to Oakland, it's vastly different. San Francisco is much more complex. If you compare San Francisco to the city of Pasadena, you'll realize that the city of Pasadena's order is very brief, but puts a stall on everything. So different cities and different counties have sprung from the governor's order to adopt each their own specific rules relating to commercial eviction moratoriums. Ezra, next slide. So here in San Francisco, in March, the mayor issued an order that established a moratorium on residential and commercial evictions in San Francisco. As discussed earlier, you have to be registered in San Francisco to do business. Your gross receipts worldwide has to be less than 25 million. And the moratorium applies to any rent that is due after March 17th. And the moratorium was just extended to include March 17th through May 17th. So that'll be March, any rent due after March 17th, any rent due in April, and now any rent due from May 1st through May 17th. Ezra, next slide. The mayor also issued a supplemental order which relates to security deposits. That order restricts the landlord's ability to collect on security deposits. What that does is that there was a fear that landlords, when their April rent was going to be paid, would just draw on the security deposits and pay itself. San Francisco came out and said, well, you could do that, but you can't use the tenant's non-payment or failure to replenish the security deposit as a grounds for eviction. And went further to say, if you draw on the security deposit, the tenant has 6 months after the emergency orders are lifted in order to repay the landlord that security deposit. So what that does is, and the order went one step further and says, we encourage landlords not to use the tenant security deposit. So that effectively kind of freezes the use of the security deposit. So what does this do? What these two orders do together is it essentially gives the tenant a 30-day opportunity to cure. So if the tenant's not paying rent and can't pay rent because of COVID-19, the order requires the landlord to give a notice to the tenant that allows the tenant up to 30 days to either pay rent or negotiate a resolution with the landlord. So think of that as a 30-day notice to cure. If the tenant is unable, if the landlord and tenant, or I should say the landlord and tenant are obligated to negotiate a resolution in good faith. So the term good faith is spelled out in the order. If the landlord and the tenant are unable to reach an agreement, then the tenant has a right to basically extend that 30-day cure period another 30 days. And it can continue to do this up to 6 months. Now, that doesn't excuse the payment of rent, but effectively defers the payment of rent for 6 months. Some technical issues to this. The order contemplates that the mayor's office will publish the form of the notice that the landlords are supposed to give to tenants. The notices were never published. Additional rules were supposed to be established relating to the enforcement of this moratorium. They never were. So there's some things that are missing on the implementation of this eviction moratorium. But you will, when you start handling these cases, you'll realize that a lot of landlords are not following this order and will not give that first notice to the tenant that they have 30 days to pay or to reach an agreement with the landlord. So what has been developed is a form of a letter. We ask the tenant to be proactive and to send a letter to the landlord stating that the tenant is unable to pay rent due to COVID-19. Businesses have been shut down, and the tenant is invoking the tenant's right under the commercial eviction moratorium to require the landlord to negotiate a resolution in good faith. Ezra, next slide. Oh, sorry, I jumped ahead. And you want to cover land use leverage?
Sure, Ezra. Thanks. So the first point on there, code compliance for open building permits. Again, these are just levers, points to bring up with the landlord. One thing you can do is check on the SF sort of zoning or property site to make sure that there are no open permits for the particular place of business for your client. I'm sure there's analogous site for other cities, but this really is just a way to say, hey, is our lease really viable if there are open issues with our space? So just another level of the landlord. The second point here, retail vacancy ordinance. As you guys may know, there was a vacancy tax that, was passed recently, I think in November of last year. What it says is that if landlords keep certain properties vacant for a certain period of time, they will be assessed a tax. So this really just works in the tenant's favor because it's a bit of pressure for the landlord to keep their space occupied. So if you want to bring that up and say, hey, this might be a difficult market with COVID, or I guess post-COVID, when it comes to getting tenants, we would both be a lot better off if you allow my business to survive and let me operate in the space and you're not hit with this penalty. So again, another lever. Ezra? Lawful non-conforming use. Alan, I'm going to turn that one over to you.
Yeah, this is think of a tenant who is operating a business or theater. This comes up often in theater companies, but is operating a business or is in the performance arts business, and the space is permitted and might have been permitted before the adoption of a land use regulation. So it's what we call a lawful non-conforming use, or sometimes people said the use was grandfathered in. As a lawful non-conforming use, if the space should roll and the tenant should move out, there is a requirement that the same use has to be put in place. Otherwise, the landlord will lose that lawful non-conforming use status. So sometimes on both of these land use issues, retail vacancy ordinance or the lawful non-conforming use, you can sometimes use those as levers in your negotiation with the landlord to say you don't want the tenant to leave, because if the tenant leaves, you could be subject to the retail vacancy tax possible. Or if the tenant leaves, that you could lose a lawful non-conforming use, and you would have to put it in a tenant that is permitted. sometimes instances where this comes up, it could be, ground floor tenant that's not a retail use, but it could be a performing arts company that the use is grandfathered in, but if it goes out, maybe the space has to be converted back to a garage. I don't know, but that could be one of the levers that you use. And certainly we can mentor you and help you in your negotiations if these issues might come up. Ezra? So, first bullet point, a lot of these rent relief structures are very, very short term. What we're seeing so far are very short term viewpoints. Like the people are thinking in 30-day increments. As you know, the emergency orders are not 30 days. They've been extended 30 days, 60 days. And I think in your negotiations with the landlord, you can try to negotiate with the landlord for a longer period of time other than 30, 60 days, because you don't know when these emergency orders are going to be lifted. Plus, particularly for the retail tenants, you don't know once the orders are lifted, what the world's going to look like. It's not going to be like a flip of the switch and all of a sudden I can open my restaurant and I'm going to have all these patrons. It's going to be, I could open my restaurant, but I'm only going to have 25 or 50% of the business. So when you negotiate with the landlord, keep in mind that these short-term rent structures that the landlord will offer, or hopefully will offer, are short-sighted, because there has to be a longer-term view to allow your client to ramp up its business and get back on its feet. Plus, revenue models may change. Going back to the restaurant, you might only have 25% or 50% of the patrons. That may not be enough to cover the operating expenses of the business. That's our next slide. And I think, another thing that you should take a look at is the difference between the type of uses that the clients might face. Office, we're not seeing a lot of office rent relief given by landlords. There might be some small percentages taken off the monthly rent, but one argument you'll hear if you're representing an office tenant is, well, you could work from home. And many of us are remotely working. And so the office tenants might be less sympathetic unless they're receiving a lot of foot traffic from visitors, then that might be a different argument. Certainly office tenants are hurting, but you'll hear a lot of landlords who are less sympathetic to office. Retail is a different category. It is just getting decimated. And that is one category where we could help those retail tenants negotiate better structures. And, we're seeing some landlords who are sympathetic to retail tenants. Often it's like 50% off the monthly base rent, which helps them. Some are looking for a longer or more of a rent concession, like free rent for 2 months and then 50%, going back to the ability to get back on your feet. Some are proposing percentage rent where the tenant's just giving a percentage of sales, like 10% of the gross receipts. I think landlords have to be creative and help these retail tenants. And the argument I always try to emphasize when we're negotiating these leases, when we're representing tenants, is, look, landlord, when we come out of this, you want to have tenants, particularly retail tenants, in your building to activate your space and eventually paying your rent. Some landlords get it. Many do not, and a lot of landlords will just want their rent, and those are tough battles to try to win. But with some advocacy, you might be able to get some relief for your client. Ezra, next bullet point. So some of the examples we talked about are rent concessions, rent deferrals. That's allowed by the mayor's order. Is a rent deferral. Rent still due. It's just deferred to another day. Percentage rent, which I mentioned, 10% of the gross receipts for a period of time. I don't know. There's a few examples of where that's happened. It's not frequently used. And another one is where you negotiate a lease term extension. Some will try to argue, well, we're not going to pay you rent for April, May, and June, but we'll tack it at the back end of our lease where we'll extend the term for additional 3 months, and we'll pay that rent that we just deferred on the back end. But if you do the math, it still equates to a 3-month rent concession, but the tenant will argue that even though you're giving me this rent concession, I am giving you more rent at the back end. Some landlords, think that that's a good idea and will go for it. Not all of them, because they want the rent today. Another example of a lease term extension that could work in your negotiations is what we call the blend and extend, where you take the 3 months of rent or 4 months of rent, however much is being deferred, and you say, well, I'm not going to pay you rent for April, May, June, and July, but for those 4 months, I'm going to pay it back to you over this period of time, so a little bit each month, and I'm going to extend that lease out for another 2 years or 3 years at a new rental rate. And landlords may go for that, especially if the lease is about to expire, because there's a longer stream of income, longer term income for the landlord. So that may incentivize the landlord to enter into this agreement. Something that is a constant problem or feedback, I'll say, from the landlord is as you're negotiating these terms, they'll say, well, just get a loan or just get, the PPP money that's available from the federal government or from the SBA. That sort of helps because these PPP loans, 75% of the money that's awarded has to go to payroll. So that could be wages, benefits, etc., but it has to go to payroll. 25% can go to the payment of rent. But if you do the math, let's say, you get a $10,000 award, $10,000 award, and you get only $2,500 can go to rent. So that might cover 1 month's rent, maybe a little bit more, like partial of the second month. But if the client is shut down, June, July, that's not going to help them. And so that has to be part of the negotiations, or the pushback to the landlord is PPP is great, but it's not going to be the solution to the payment of rent, that something needs to be worked out. Ezra? One thing to also think about is business interruption insurance. Definitely have your client take a look at its business interruption insurance and to make a claim against its policy. The challenge there is that a lot of the claims are being denied by the insurance carriers, but definitely have the tenant pursue its business interruption insurance. There's going to be a common exclusion called the contagion exclusion, that the insurance company doesn't cover contagion. My argument back is the shutdown of the business is not necessarily due solely to a contagion. It's also due to an intervening government order. So there has been some discussion in other states to require insurers to cover losses due to COVID-19. I know New Jersey has legislation pending. Not sure if California will also follow suit. Ezra? Andy, might talk about the different programs that could be available to tenants?
Sure. But sorry, Ezra, can you go back to the last slide? I just wanted to make one point to what Alan was saying about the rent relief structures and the concessions. So, when it comes to the different strategies that you're pursuing and the different structures that a landlord might offer, it's really important to think about sort of the viability of the tenant. Even with what they're giving, like in the long term, is this going to work? With just what Alan was saying. So one thing that we've seen in some of these sort of amendments that landlords are drafting, particularly savvier landlords, is they're saying that, okay, yes, we'll give you this concession, whether it's an abatement, deferral, percentage rent, extension, whatever it is, but that there's a callback component to it. So if there's an event of default after we forgive your rent, essentially we get to take that back, and all that rent that we've forgiven essentially it comes back into effect, and you owe us that money. Now, COVID, rent negotiations, or really in any sort of market transaction, that's a very typical thing that we see, and it's very reasonable. But because we are dealing with smaller tenants here, and obviously given the COVID climate, we just have to be extra aware of are they going to be viable even with the forgiveness or even with the concession? Because if they're not, the forgiveness really doesn't mean anything, because with the clawback, it all comes back into effect anyway. That's right. If you can get to the next slide. So here are just some resources. Government assistance is listed on the left-hand side. I'm sure you guys have heard about a lot of these. SBA loans, EIDL, a PPP program. We've heard a lot of folks, particularly the smaller tenants and smaller businesses, aren't really able to access these days, just because it does depend a lot on banking relationships and kind of who gets there first. So we are also recommending that folks check out private sources of funding. So that's listed on the right-hand side there. Facebook. We heard about this Local Initiatives Support Corporation. I'm sure there are others out there. Maybe it's a Google search. But yeah, it's not just relying on federal funds at this point. Alan, anything else?
I think just the point, I think what we're doing is important work. If we want San Francisco or our communities, particularly Asian American communities, if we want to come out of this, when we come out of this, if we still want to see a J-town, or we still want to see a Chinatown, a little Saigon, we have to do something to keep these businesses alive. If we want to continue to have San Francisco look like San Francisco, everybody has to work together. The landlords, the tenants, the banks, everyone has to work with each other, because this is a very fragile ecosystem. And as soon as one party to that ecosystem starts to defend its own turf, there will be no ecosystem. And that's an appeal I've tried to make to landlords. Some have accepted it, but some are very selfish in looking at only the rent that's coming to them. But I think what you're doing is important work, and I thank you for participating and volunteering your time to help us save Asian American communities. Ezra, is there any questions? Yeah.
Alan, I'll let you take that one. It sounds like it's part of a negotiation.
Yeah, it's hard to. The question is, if you've already paid rent in March and your business will not survive until you get that rent back, would you be able to ask it back? The answer is unlikely. The only thing I could think of is if you paid rent in March, you haven't paid April, and there's a security deposit, is to negotiate the security deposit to stretch into April, 50% in April, 50% in May, and replenish that security deposit 6 months after the emergency order is lifted, which is required by the mayor's order if this business is in San Francisco. It is unlikely you could get that rent back from the landlord, but I would use the rent that's already been paid as some sort of leverage to structure a longer term structure over a period of time. Sorry, one more question. Looks like no one else is asking. Well, that's fine. Use PP money to pay rent over 20% of that amount and let her pay the government back. I don't know. I think it's a hard cap at 75%. 75% has to go towards employee costs. And so that, again, this is going to be a negotiation with the landlord, is that here's, and what I think also helps in these negotiations is transparency. So, not only should the tenant show the award that came from the PPP program, and how much is available, how much they received, but also show how much is available. So going to the example, a $10,000 award, $2,500 can go toward rent. Landlord, you have to work with me with this cash that's made available. And that's really transparency. I don't think you could exceed that number, but we could look into it and get back to you. Something also that is important in these negotiations is having the financial statements available to help make your case to the landlord that business is really suffering. Landlords like to see the detail that's made available at the outset of the negotiations. Of course, last year's fiscal year statements kind of irrelevant, right? Because what's important is what the tenant's cash position is today or in April. And April and May, if you can have your client prepare cash statements or even income statements, that would be helpful in your negotiations with the landlord, together with any traffic that has come to the site. Most places are completely shut down, but a common argument that a landlord will make, well, what, haven't you been selling anything online? No, I sell boba tea, so it's hard for to sell that online. So I think it's that discussion of being transparent, having the financial statements would start off the negotiations well.
And I'll add to that we recognize a lot of small businesses might not always have their financials in order. So now might be the time to kind of get at least the last couple months started, because in addition to it being helpful to the landlord, when you are sending that notice to the landlord saying, I can't pay rent, let's enter into negotiations. I think the directive does say something like financials are more or less required to show, your hardship or your impact from COVID.
Yeah, and that's a good point. And having the discussions earlier than later is also helpful too.
I think that was all of our questions. So on behalf of AABA, I want to thank Alan and Anne for leading this great training. And I want to extend AABA's thank you to all of our volunteers for the work that you are doing, and echo Alan's comments on the importance of this work that we are going to be doing for the Asian American and APA community in San Francisco and in the Bay Area.
Thank you, Ezra. Thank you, everyone.
Thanks,
and look forward to working with you.